Good morning. This is the Judicial Committee of the Privy Council hearing the appeal in the case of Ciban Management Corporation and Citco BVI Limited and another. We are currently hearing the submissions of Mr. Stephen Thompson QC on behalf of the respondents. Mr. Thompson.
Good morning, my lord, my lords and ladies. I was making submissions yesterday in various regards and made a rash promise that I'd be done in half an hour. Looking over my notes overnight, I suspect that might have been over optimistic, and I beg your leave to withdraw that promise. But can I indicate what I hope to deal with today? Still, I hope it won't take the 2 hours of that I have allocated to me.
Thompson, it wasn't a promise, it was an estimate, but you're entitled to withdraw your estimate.
Well, I'm very grateful. I dare say your lordship is very familiar with council making poor estimates and having to withdraw them, and I apologise on my behalf. So, my lord, the first thing I will do, if I may, is just to pick up a few references that I made yesterday, which I think my Lady Arden asked me specifically whether they had been addressed before the trial judge, and I just wanted to give, for everyone's benefit, the references to show that they were. In some instances, and again it's another correction and apology I should present, it wasn't a matter of my putting the documents specifically to Mr. Byington, but rather they were presented in opening or in argument, and we have most of the transcript. I think there's half a day missing, but we have all the references to the documents which I took the board to yesterday. Then I will complete my submissions in relation to what I call the multinational gas point, touching upon Meridian and Duomatic in the course of that. And if I can then, once I've dealt with that, revert back belatedly to my Lady Arden's question about red flags in that context, and then finally deal with why in my submission Singularis, Bilter and Nazir and Stone and Rolls are nothing to the point and cannot assist the appellants in this case. So dealing first then with, I think it's 4 points that I made yesterday in relation to documents. I took your lordships and your ladyships to some emails passing between Mr. Costa and Mr. Byington in March, April, May of 2001, in order to demonstrate that their business relationship had not terminated, as might have been thought at November 2000 on that sending and receipt of that termination letter. Those documents in your notes would have been in the record at pages 1400, 404, 5, 6, and 8, and those are the emails I took you to yesterday. Again, for your just to assure the panel that they were before Mr. Justice Bannister, can I ask you to look briefly at page 275 of the record? This is Mr. Hubble, acting then as now for the appellants, the claimant company, in his opening. And at 275, you can see at the beginning of that page, there is a string, I suspect that is, of emails that passed between Mr. Costa and Mr. Byington in the period in the first half of 2001. The first I take you to here is that of the 21st of March 2001. And then he reads to that email, which I read to you yesterday. At the bottom of the page, last two lines, if you go on to page 173, there's a further email of the 6th of May. That's page 1404 of the record. And going over the page, you can see he draws the judge's attention to various matters that are referred to there about Norman's son, see down at line 16. And then at 277 of the record, line 4, Mr. Hubble refers to the email of the 7th of May, which is one I took you to as well, the reference to those BVI companies at line 11, Spectacular Waterloo, Polar Sky, Xerox, My Responsibility, and over the page at 278, line 11, again, the reference to 177, more of the same, the judge says, and that's a reference to the page that you now see at 1408, 11th of May email. So those 4 emails, I think they are, between March and May 2001 were before the judge at first instance, and indeed Mr. Hubble expressly took the judge to them in his opening. In relation to the later document, this is the document, just to remind you, at 2056, which was the document I took you to, that was described as handwritten, but I think on review it was actually just a transcription of an email. 2056 was the email by which Mr. Costa informed Mr. Byington of the sale on the 14th of December 2001. I think this was the one which specifically my Lady Arden asked me about. Now, you can see from Mr. Justice Bannister's decision, his judgment at paragraph 14, that he refers to this particular email, not in terms, but he indicates that there was a notification by Mr. Costa to Mr. Byington of the fact of sale, and he describes that as a sort of completion statement before referring to the response at paragraph 15 of the judgment. Again, if you look at the transcript just for completeness at page 298, you can see that Mr. Hubble again in his opening referred specifically to this. And you can see at the bottom of that page, line 22, Mr. Hubble says, yes, one sees that there is an email from Mr. Costa to Mr. Byington. The subject is sale of building 14th of December 2011, and I wanted to take you to 480, is what I understand to be the attachment to that email. It ended up being exhibited to Mr. Costa's defence in the title action. And you can see from line 11, Mr. Hubble reading that sentence from that email, in fact, quite a lot of that email, out to the judge. So that was specifically referred to. Again, for completeness, if you look at 2343, which was Mr. Byington's reply, you can see actually how this came about, because at 2343, which is the "you must be joking" email, you can see that in the bottom half of that printout, there is the original email from Mr. Costa, which says, Alberto, see attached. And that's why Mr. Hubble said the attachment is at page 480 of the trial bundle it was, and it had been dug out of the Brazilian action, and in fact disclosed by the claimants, not the defendants, for what it, but by the defendants, not the claimants, for what it's worth. So that's tracing that through, which I hope answers, albeit somewhat laboriously, my Lady Arden's question. I also made reference yesterday to the fact that there was an instruction given to the defendants to cancel the powers of attorney. I think this was in answer to my Lord Hodges' question. Again, if you look at Mr. Justice Bannister's decision at paragraph 16, he makes express reference to this. 2123 of the record, paragraph 16, Justice Bannister refers to the fact that Mr. Green, another lawyer acting for Mr. Byington, it would seem, directed the BVI companies to revoke the powers of attorney, and we do have that. And if you look at page 1467, and you see a covering email from Nixia Titley, who works in the BVI for the respondents, saying, "Hi, John, attached is the resolution revoking the powers of attorney along with the copies of the powers. I also attached a copy of the director's certificate. Thank you for your attention to this matter. Please not hesitate to contact us if you have any questions." And it's actually the page before, which is obviously the attachment, 1466, dated the same day, 19th of December 2001, revoking all 5 of the powers of attorney just after the sale of the property had been notified to Mr. Byington. So it may well have been that they considered this belt and braces, and I don't attempt to address the question about whether the powers of attorney, the first to fourth, remained in place, but on the face of it, Mr. Byington and his Floridan lawyers thought fit here to pass a resolution to revoke all of them after he had learnt of the sale. The last point, picking up on bits and pieces from yesterday, was I think another issue raised by my Lady Arden about the property and any rent which might have been derived from the property. This was a topic of cross-examination of Mr. Byington on at the trial, which took up a little bit of time, and I don't intend to take your lordships and ladyships through it, but it starts at page 370 of the transcript. And if I can simply summarize what it says there, Mr. Byington gave evidence that there were, sorry, let me put this into context, there had been a request for further information made, which is not in the record now, but was before the trial judge, about the rent. And if you look at page 370 of the transcript, you can see my asking the question starts right at the top of the page. I want you to look at tab 6. Can you see the tab numbers, number 6? Now go to page 2. Just to tell you what this document is, this is a document that your former lawyer prepared with answer to some questions. It's an answer to a request for further information. And I just want to show you, I asked him one answer here, and you can tell me if it's true or not. And the question was, as the witness actually read out, what was the annual commercial rent that the claimant derived from the property each year between its incorporation in 1996 and the commencement of the claim for loss of commercial rent? And so I said, it's asking for the rent Spectacular received between 96 and 2000. And the answer, which I read out, which was the answer on paper, was at line 16, from the date of its incorporation until December 2001, the claimant did not derive commercial rent from the property. But then Mr. Byington says, not derive commercial rent, yes, but very small rent, very small rent. So I asked him, did it receive rent or not? Yes, wait a second, I'm almost sure that we received rent because there were some people here, as you read the list of companies, they're not our companies, so some probably paid rent, because the answer also had a list of various companies which had occupied the building. But then there's a vagueness in his answers, and we don't get to any specific answer about that. There's a lot of discussion about whether it was a lot of rent or a small amount of rent. And then I took him to, later on, a document which we don't have in the record, which was in fact a lease between Spectacular as the landlord and GL as the tenant. And you can see that that's, I start referring to that at page 376 of the transcript. You don't have it, I'm afraid, in your record, but you can see at the bottom of page 376, line 23, I recited some of its terms. It says here, 2nd of January 1999, it seems to be a lease of this building in Avenida do Estado 4667. If you look at page 133A, that's what it looks like, isn't it? And he confirms at line 6, this is a lease, and the monthly rent is 8,000 reals. And I asked him at line 19 who received the rent, a question which he either didn't understand or didn't hear, and I repeated it. And he says, well, it says here who's renting and who's receiving, so the one who's renting it is Spectacular. And I said, right, but Spectacular didn't have a bank account, did it? No bank account. So who received the rent? Most likely my company. Who paid the rent? GL. So this lease doesn't show us what it says. It doesn't show us that money is paid from GL. And we go a little bit round in circles, but at the end of it, I said to him at line 16, why would you need a lease like this, Mr. Byington? The money is going from one pocket to another. I need a lease like this, most likely for juridical situations in Sao Paulo, Brazil. What does that mean? I asked him. I don't know. And then he said, to follow up that question, which I thought was quite clear, it's supposed to be compatible with fiscal requirements, with legal requirements of running a company. That I don't know. I cannot tell you exactly what it is, how, why you need a lease contract. But I'm here trying to guess something here, and I advised him not to guess. What the tenor of all this evidence is that he had documents in place for juridical purposes or fiscal requirements, as he put it, whatever they might have meant. But he didn't, in fact, seem to have any recollection, and there's certainly no evidence about any rent, commercial or otherwise, which was paid or received. And that was of a piece with Mr. Byington's evidence generally, which is that he treated all of these things rather as his own companies, and he could do what he liked with them, their assets and their money.
Is the consequence of that then, Mr. Thompson, that Spectacular, having no bank account, was simply a vehicle for holding the title to the property, leaving the beneficial owner, in effect, to pocket the proceeds?
Well, yes, my lord, it is.
That seems to be what it amounts to.
Yes, I'll build upon that submission if I may, but the short answer to your lordship's question is yes. As you saw yesterday, the purpose of the company is set up as a property holding company. That's what the judge found, and that's what the paperwork suggests. That's what everyone thought it was doing. It is not a trading company. It's not even a company in the business of property leasing. It's just a holding company. And without pushing the boundaries too much of the differences between companies in the BVI compared to elsewhere, the reality is, as the panel will be well aware, that there are many offshore entities which are set up specifically for good, bad, tax and more nefarious reasons to hold assets rather than actually to trade with those assets. And sometimes, obviously, they're used as vehicles for fraud, but sometimes they're used merely to save tax, sometimes, no doubt, to evade tax in various other jurisdictions. But what Mr. Byington clearly is using this entity for is just to hold these properties. It doesn't have a bank account, it doesn't trade, it doesn't receive the rent.
I made a note yesterday. I'm sorry, I hope I'm not interrupting Lord Hodge, because it was Lord Hodge's question. You made a point yesterday, well, Mr. Byington was defrauding the creditors. That was something you said, and I made a note, and I hope I got that accurately. I mean, what it looks to be the case here is that he's extracting money from GEL, which had been in financial difficulty. Not a huge sum, but he was extracting some. And it was pocketing it, as Lord Hodge said. Would that be a fair analysis?
Yeah, yes, it is. And I mean, don't make that submission out of the ether. That is what the judge effectively found in paragraphs 2 to 5 of his judgment. He effectively describes, and it's based on Mr. Byington's candid answers in cross-examination. The judge found that Mr. Byington had sued GEL, trying to give the impression to the authorities and the court in Brazil that this was an arm's length sale, but he'd done it solely in order to extract the property from GEL in order to avoid it falling into the hands of GEL's creditors. And that is an express finding of the judge in paragraph 4 of the judgment, and there can't be and has not been any appeal from it. It's part of the background of the story, and I don't suggest that it has any great forensic value today, save that it is obviously the case that this is the purpose for which this company was set up. It was set up in order to ensure that Mr. Byington got his hands on the property at the expense of the creditors of GEL. That is, without exaggerating it, a fraud on the creditors. So that's what I would call the sweeping up from yesterday. I'm very grateful, and I don't know if that answers my Lord Hodge and my Lady Arden's questions on that point. I was going to move on.
No, I'm quite content with that. It's just I was testing the judge's conclusion that in effect that Spectacular was there to hold title to the property and obey Mr. Byington's instructions.
Yes, in my submission, that was an impeccable decision by the learned judge, and the evidence supports it, and it couldn't be attacked at any appellate level, and it's fully justified as a conclusion, and consequences flow from that, particularly when I address the red flags point, which I intend to come back to in due course.
Thank you, Mr. Thompson.
I'm very grateful. I hope I've addressed my Lady Arden's questions as well on that. I'm extremely grateful. In which case, can I turn to what I had imagined wrongly might be the main point of the appeal, which is what I call the multinational gas point, but it could equally be called Duomatic or the Meridian point. And what I want to do with this, just to give the board an indication of the structure of my submissions, is take your lordships and ladyships through the critical passages in multinational gas and Meridian, and then make submissions on what the limits of that principle are, and how they apply to this case. Can I start then by taking you to multinational gas itself? I needn't, I think, in the light of the discussion, take you through it in a lot of detail, but I only want to take you to the judgments of Lord Justice Lawton and Lord Justice Dillon. Lord Justice Lawton, if you can turn to page 2790 of the record. Actually, can I ask you to pick it up at 2789, the page before, 2789. It was a case about whether there should be permission to serve out, but this part of the judgment is deciding whether or not there is any tenable case against the defendants, and the argument put forward by the defendants was that there could not be, because the act which was complained about would have to be, as a matter of law, taken to be an act of the company, which would therefore leave the claimants without a cause of action, and therefore leave should not be given. The submission of the defendants is set out in Lord Justice Lawton's judgment at page 2789 at letter F. And I'll read it if I may. The submission in relation to the defendants was as follows. No allegation had been made that the plaintiff's directors had acted ultra vires or in bad faith. What was alleged was that when making the decisions which were alleged to have caused the plaintiff loss and giving instructions to services to put them into effect, they had acted in accordance with the directions and behest of the three oil companies. These oil companies were the only shareholders. All the acts complained of became the plaintiff's acts. The plaintiff, although it had a separate existence from its oil company shareholders, existed for the benefit of those shareholders who, provided they acted intra vires and in good faith, could manage the plaintiff's affairs if they wished. If they wanted to take business risks through the plaintiff, which no prudent businessman would take, they could lawfully do so, just as an individual can act like a fool, provided he keeps it in the law, so could the plaintiff. But in its case, it was for the shareholders to decide whether the plaintiff should act foolishly. As shareholders, they had no duty to those with whom the plaintiff did business. It was for such persons to assess the hazards of doing business with them. It followed, so it was submitted, that the plaintiffs, as a matter of law, could not now complain about what it did at the shareholders' behest. And over the page, you can see Lord Justice Lawton explains the assumptions behind that submission and effectively accepts it. This submission, Lord Justice Lawton goes on, was based upon the assumption for which there was evidence that Liberian company law was the same as English company law, and upon a long line of cases starting with Salomon and Salomon ending with the decision in this court in Horsley and Wade. In my judgment, these cases established the following relevant principles of law. First, that the plaintiff was at law a different legal person from the subscribing oil company's shareholders and was not their agent, see Salomon. Secondly, that the oil companies as shareholders were not liable to anyone except to the extent and manner provided by the Companies Act. See the same case, the same page. Thirdly, that when the oil companies acting together required the plaintiff's directors to make decisions or approve what they had done, what they did or approved became the plaintiff's act and were binding upon it. And that's the critical passage for the purposes of today. Now, sorry, I'm having a minor technology problem, but seem to have lost the bundle. But I might be able to survive without it for a moment. And at the end of that paragraph at D, what the oil companies were doing was adopting the Directors' Acts and as shareholders in agreement with each other, making those acts the plaintiffs' acts. It follows, so it seems to me, that the plaintiffs cannot complain about what in law were its own acts. Lord Justice May on the next page gave a dissenting judgment which has not subsequently gained any traction, so I'll pass over it. Lord Justice Dillon was the other director, judge in the Court of Appeal, and could you ask you to look at page 2809 for what he said? Starting 3 lines down, certain fundamental facts are not in dispute. One, it is not alleged and could not be alleged that the making of any of the contracts or arrangements authorised at the 3 board meetings of which complaint is made was ultra vires the plaintiff or in any way illegal. On the contrary, they were well in line with the plaintiff's main objects. 2, it is not alleged that the plaintiff was insolvent when the board meetings were held. On the contrary, the figures pleaded in the statement of claim, plaintiffs traded profitably and so on. And then at C3, it is not alleged that the joint venturers or the directors of the plaintiff acted fraudulently or in bad faith in any way or were guilty of fraudulent trading. What is alleged is that they all acted negligently in that they made 5 speculative decisions in relation to the ships when they knew or ought to have known that they did not have sufficient information to make sensible business decisions. These decisions, which they took in good faith, went into set outside the range of reasonable commercial judgment. The heart of the matter is therefore that certain commercial decisions which were not ultra vires to the plaintiff were made honestly and not merely by the directors but by all the shareholders of the plaintiff at a time when the plaintiff was solvent. I do not see how there can be any complaint of that. An individual trader who is solvent is free to make stupid but honest commercial decisions in the conduct of his own business. He owes no duty of care to future creditors. The same applies to a partnership of individuals. A company, as it seems to me, likewise owes no duty of care to future creditors. I pause here to say parenthetically, because I will come back to, and I hope the case of Sequana has reached you overnight. I will come back to touch upon this point. Lord Justice Dillon was the judge who gave the leading judgment in West Mercia and Dodds, the certainly until Sequana, the leading or at least the seminal case on what duties directors owed to creditors and when in cases of insolvency or near insolvency. That decision, West Mercia, was decided in 1988, and as I will show you, Lord Justice Dillon referred back to this case in making the decision in West Mercia, and those two decisions are not in any way incompatible, not least because they were made by the same judge. But I'll come back to that point if I may. I ought to have checked whether the case of Sequana, BTI and Sequana has reached you overnight. I apologise that it wasn't in the bundle previously, but I asked the registry to pass it on to you, and I'm very grateful that
we have it in front of us. Thank you.
I'm very grateful. Then, if you will, can we go to Meridian, a decision of the Privy Council, and the only section which is relevant is the very famous passage which is in the record at 2834, Lord Hoffman explaining definitively how the rules of attribution work in relation to companies. Now, just pausing here, as I said yesterday, this case before the board today is not a case about attribution of any individual to a company. The question of ostensible authority that I addressed yesterday is the question of whether Mr. Costa had the ostensible authority of Mr. Byington as a shareholder. It is not the case. This is a question of attribution to the company, save insofar as you are addressing the question of whether Mr. Byington actions could be said to be actions of the company. So the whole structure of my submissions today on this point, on the Meridian and multinational gas case, are on the premise that you are with me on the ostensible authority question. That is to say, if I am right that as a matter of law and fact, Mr. Costa had the authority, ostensible authority, to give instructions to the director on behalf of Mr. Byington, then the question simply becomes whether Mr. Byington's acts, as they would then be, or instructions, are to be taken to be acts of the company. That's the only premise, that's the only point of the attribution question here. And Lord Hoffman, of course, famously sets out the three different sources of the rules of attribution, but within the category of the primary rules of attribution, there are those implied by company law, and he expressly refers at E to multinational gas. Although, as far as I can tell, despite the fact that those words are in quotation marks, that isn't in fact words that were spoken by the judges in multinational gas. But be that as it may, it is evident, if it needs me to say it, that is the ratio of the case in multinational gas. And interestingly, Lord Hoffman, in his summary of the ratio of multinational gas, doesn't actually mention bona fides or fraud. He simply says the unanimous decision of all the shareholders in a solvent company about anything which the company under its memorandum of association has power to do shall be the decision of the company. So pausing there before we go back.
But you would accept, wouldn't you, that the courts had laid down in relation to the duomatic principle that to which the shareholders give assent must not be a fraud. Yes, it's a matter of judicial policy. If the courts are not going to require formalities to be gone through, they can lay down conditions. And what it appears is that they've laid down the condition, understandably, it should not be a fraud.
Absolutely, my lady. And I'm not going to lose sight of this point. I'm going to address it square on immediately, because I do accept that there are three limitations then on the shareholders' power to act on behalf of the company. And the three limitations are that the company is not insolvent, that the act is not illegal or ultra vires, and that it is not a fraudulent act. But I want to address the first and third of those in more detail. And let me address the question of fraud and bad faith first. Well, as a preface to this, let me just put duomatic into this context. Duomatic obviously deals with the same rule here, but it's a variant of the rule because really what it is dealing with on its true facts was the formality of the meeting, and really the principle in duomatic is whether or not there needs to be a general meeting so called in order for acts of the shareholders to become acts of the company. And duomatic effectively says that there is a rule doing away with the necessity of formality if in fact it is clear that that is what is happening, even if the meeting is of individuals who happen to be both directors and shareholders, which was the case obviously in duomatic itself. And before I go to look at the exceptions, there is no logic to the submission made by Mr. Hubble that the general rules of agency shouldn't apply to this principle. Mr. Hubble submits that what I'm asking the court to do here is to extend the duomatic principle, but that simply isn't the case. All I am suggesting is that the general law on agency applies to members of the company just as it applies to anybody else. And that, in my submission, must be right. If you take a very simple case of a small business with two members, let's say they were friends and it's a quasi-partnership, one of them is in the habit of passing his instructions through his wife or his son or her sister or whoever it might be, and in fact, as a matter of law, has clothed that person with ostensible, if not actual, authority, then obviously it must be right that if those, if any decisions or acts of that particular member come through the agent clothed with ostensible authority, then taken with the other shareholder, they will be acts of the company. There's nothing unorthodox in that. It must be right, as Lord Hoffman emphasises in Meridian, that the general law of agency applies in this context as much as any other. And so really what Mr. Hubble is inviting you to do is to make an exception to the law in geomatic and multinational gas in the case of ostensible authority. But there's no possible logical reason to do so. The laws of agency aren't suspended in this circumstance.
But do you actually need ostensible authority? The judge said this is actual authority. All that happens is that the ultimate beneficial owner, Mr. Byington, gives instructions implicitly over a course of conduct that TCCL shall act on the instructions of Mr. Costa. And that is what, on the judge's view, is the beginning and the end of what Mr. Byington has done. So it's a sort of catch-all type authority. He's vested actual authority in TCCL. And obviously that's agency plus Dumatic stapled together.
Yes. Obviously, the judge didn't consider that the case was one in engaging the principles of ostensible authority at all. And it is obviously the case, as the judge found, that Mr. Costa had actual authority for the first four powers of attorney. And so there is then a potential argument that the authority, if it is terminated, but no notice of that termination is given, then the authority can be deemed to continue. That's the passage in Bousted that I've cited in my case at 10-30. Sorry, my lady.
No, I didn't mean to interrupt. Sorry.
Well, I'm scared I'm not addressing your ladyship's question. So please.
What I thought it could be said was the judge has reached a finding of actual authority even for the POA 5, because what he is saying is he's told TCCL by conduct that they are to accept whatever Mr. Costa says. He, Mr. Byington, is not prepared to go on record. So if it's a document which requires execution in writing by the company, Costa will tell TCL to execute it so that Mr. Byington's name appears nowhere.
Yeah, well, I mean, certainly as a matter of fact, that is what the judge found actually happened. I hesitate before nailing my colours to the mast about whether that should be characterised as actual or ostensible authority, and it may be more for Mr. Hubble to answer your ladyship question than mine, because, put it bluntly, it doesn't matter much to my case whether it's one or t'other. But if it is ostensible authority, then in my submission, the stapling together is just as orthodox as it would be if it were actual authority. My Lord,
sorry.
If that answers your question, I can see my Lord Legate has
I was going to say, it still leaves the first stage. It is a stapling together. So you've got to jump over the Dumatic hurdle because there was no formality in Spectacular to give you that authority. And you have to rely on the rules of agency, but they're stapled together.
Well, my lady, yes, but there's nothing in law or logic to deny the stapling together. One is simply applying the general law using principles, admittedly in 2 lines of cases, distinctly to the facts of the case. And there's no reason to support Mr. Hubbell's submission that somehow these two can't be stapled together because of the facts of this case.
Right, and we'll come on to limits later.
My lady, yes.
Thank you.
Thank
Lord
you.
Leggett.
My question, Mr. Thompson, is whether we really need to be concerned with ostensible authority that we're spending so much time on at all, or whether the judge wasn't perfectly entitled to regard the question as being whether the director was negligent in failing to question Mr. Costa's authority.
Well,
as long as one accepts the duomatic principle, and that in principle you can communicate your instructions as a shareholder through an agent, then it matters not whether he actually was authorised or ostensibly authorised, provided that it was reasonable for the director to believe that he was authorised and to proceed on the basis that he was, given the background of the way the arrangements had been set up. And then the judge was entitled to come, wasn't he, to the conclusion he did?
Well, in my respectful submission, yes, he was, my lord. I'm addressing what's said against me, and the counter argument being, I think, that the respondents weren't reasonable to assume that was the case, and that there was they were put on inquiry about the authority in the first place. And I think the way Mr. Hubbell put it, and certainly when bolstered with the point my Lady Arden made yesterday, is that the facts of the case meant that it wasn't reasonable for the respondents to rely upon Mr. Costa at the point of the 5th power of attorney because of the red flags associated with that request. But I mean, my lord, is again to answer your lordship as bluntly as answered my lady, it probably doesn't matter to me one way or the other. That is certainly the way the judge addressed the question, because as your lordship knows, he didn't think ostensible authority was anything to the point. The Court of Appeal differed on that point, but frankly, either which way comes round to the same conclusion.
Mr. Thompson, Lord Burrows has a question for you.
Yes, I can see that it might not matter for you, Mr. Thompson, in relation to the claim for breach of the duty of care, but aren't you going to then run into an issue over Section 80, on which you're going to have to rely on, as I understand it, this, what has been termed by Lady Arden, the stapling together of ostensible authority or the law of agency plus duomatic, because reasonable care isn't an issue there.
Well, that's right, but if it is the case that under the principles of agency, Mr. Costa did have the authority of Mr. Byington, then that's a complete answer to Section 80 as well, because the effect...
No, I take that point, but I think the argument being put to you by Lord Leggett was, why are you even bothering with ostensible authority? Because this is all a question of whether there was reasonable care taken by the directors, and there's a finding that there was reasonable care. And you might say, well, that might answer that issue, but it wouldn't answer for you, would it, as I understand it, the Section 80 point?
Yes, that's probably the case. I mean, I have various other grounds on which I would submit Section 80 doesn't even get off the ground. But if it comes down to if I'm wrong about all my other points on Section 80, then obviously it does need to be the case that Mr. Byington actually approved the transaction through his authority of Mr. Costa. So yes, my lord, in those circumstances, that is to say, if I'm wrong about all my other Section 80 points, then I would need the authority point in order to get home on that. I think that must be right.
For that reason, I think we should let you develop your submission on the relationship between ostensible authority and the duomatic principle.
I'm very grateful, my lord. I hope I've addressed the other questions on that. So, in relation then to the three limitations on the principle and multinational gas, can I turn to the fraud and bad faith point, which is echoed in Duomatic and the other cases which Mr. Hubble took you to yesterday? In my submissions, it's quite clear from looking at the cases that really what this fraud and bad faith exception is getting at is fraud and bad faith vis-a-vis third parties. Now, insofar as there is a fraud perpetrated by a company on a third party, then obviously the courts will be astute as a matter of public policy to unravel that, and it can't be something that the members or the company can hide behind. But you can see that from the fact, as I took you to, Lord Justice Dillon in his judgment talks about fraudulent trading within the context of his exceptions that he enumerates on page 2809. So really what we're here concerned about is a situation where the company is doing something that is fraudulent or in bad faith vis-a-vis its relations with third parties. Now, in this case, on the argument I'm making so far, ex hypothesis, Mr. Costa had the authority of Mr. Byington. I'm making all my submissions in relation to Duomatic on that hypothesis. Now, if he had the authority of Mr. Byington as a matter of ostensible authority, but actually he was defrauding Mr. Byington, which is obviously a possibility logically, then Mr. Byington and the company would obviously have a cause of action against Mr. Costa in fraud. He'd interposed himself in the relationship between the shareholder or the UBO of the company and its directors in order to effect a fraud. There's obviously a cause of action which the company and Mr. Byington would have against Mr. Costa. But there would be no claim in those circumstances against the directors because they would have been duped by the fraudster. That's because on this hypothesis, on this argument, Mr. Costa had the ostensible authority. So this question of bad faith and fraud does not enlighten this case one bit, because this is, even if there were bad faith and fraud perpetrated by Mr. Costa on Mr. Byington, that isn't the type of bad faith and fraud which is being put as a limit on the principle by Lord Justice Dillon, Lord Hoffman, and Mr. Justice Buckley in this line of cases. This is not the same type of fraud. The fraud and bad faith limitation is patently about fraud and bad faith on third parties. My lady, Lady Arden has a question.
Yes, please. I just want to go back one. The duomatic principle, I think you agreed, also applied to the starting point, namely when Mr. Byington vests authority in Mr. Costa to effectively feed the instructions through to TCL. He doesn't have the formality of the meeting. There's no evidence of that, and it's most unlikely. So he is the corporator, the beneficial owner of the corporators, and he gives assent to this arrangement, which detracts and diminishes the normal authority of the directors. The normal authority of directors is, of course, to conduct the business and to take the initiative in business management decisions. But all that has changed. That's what the judge found. The system is that they are just there to receive instructions. And Mr. Byington achieved that, so far as we know, through acting on the duomatic principle. That's how he gave authority to Costa and took it away from TCCL. Now, if you look at that fundamental stepping stone in the argument, could it be said, I just want some help on this, could it be said, well, actually, all of that was a fraud because what Mr. Byington was doing was setting up a vehicle to conduct a fraud on the creditors in Brazil who were not getting paid, including, I think you said, the revenue. They thought this was a pucker sale from from gel to spectacular. And in fact, it was all a setup, and Spectacular was extracting some money in the form of rent. Those creditors remained unpaid, and they're admittedly not the creditors of Spectacular, they're the creditors of gel. But that's a fraud, ex concessis.
Well, I think the answer to your ladyship question comes in looking at the distinction between cases like the one before the board and cases like Singularis and Bilter and Stone and Rolls, dare I say its name. And I think those cases show that when you're dealing with questions of fraud and the attribution of the knowledge that any particular fraudster has to a company, for example, or to any other person, that's very much context driven, and you have to look at the particular circumstances in which the claim is made. That being the law on this, in my submission, within the context of a claim made here by a solvent company, still under the control of the same member in question, then the question of fraud as the attribution of the fraud of Mr. Byington, if we're going to use that as the premise here, must obviously be attributed to the company, because it is a very different question from that arising in the Singularis and Bilter cases, where you're talking about third parties, banks, accountants, and so on, who might have been negligent in their protection of the assets of the company for the benefit of third parties. So the answer to your ladyship question, I think, comes in the distinction which has to be made according to what the context is of the particular claim. This is not a claim which involves any third parties at all. Now, there might be a very different answer to these questions on attribution if, in fact, you were here considering a claim made by or brought against strangers to the company, or auditors, bankers, creditors, and so on. But you're not. You're really here only concerned with the particular management of the company between its directors and members. And so the sorts of illegality arguments which failed in Bilter and Singularis might well have then prevailed in this case if they were advanced on that basis.
I suppose it might be said, I'm just wanting some help, that the conditions laid down by the courts in cases like multinational and in the case of rolled steel and British Steel Products, which is funnily enough not referred to in multinational or both, is that the transaction to which unanimous assent is given is not fraudulent. And as we've explained, that is potentially judicial policy, and I think, acceded to that. Might it be said that that is an objective condition, doesn't depend on anybody's actually knowing it. It is the case that if it's unanimous consent won't work in law. You can't dispense with meetings if, as it happens, on the true facts, the transaction of assent was for a fraudulent purpose.
My lady, I'm not sure the law can or should go quite that far. I think what the cases are laying down is a limitation against the informality of decisions made by members of a company, where on the particular facts there is a fraud which is perpetrated as part of that decision. If you have the circumstance where, in fact, the whole venture is a fraud, then of course, as a matter of policy, the courts might well unravel everything to do with the company from its incorporation onwards, and that must be a matter of policy open to the courts, which is pursued for that reason alone. But the limitation which is put on this particular principle is much narrower than that. The limitation on this principle is simply that the decisions of the shareholders, which are made when the company is solvent and not otherwise outside its power to do so, are not fraudulent. I mean, if you will, it's merely an extension, really, of the ultra vires point, because it can't be within the power of a company to do something which is either illegal or fraudulent. Which is why, in my submission, it might be why Lord Hoffman didn't expressly refer to it in his summary of the principle, because obviously it's not within the power of a company to perpetrate a fraud.
Well, hang on. If that can't, I think obviously be so, because if fraud is something which is ultra vires the company, no company could be guilty of a criminal offence for committing fraud.
Well,
I don't quite that, but that's not quite right.
Well, I mean, one of the I think one of the criticisms which is made, I think, in Bilter of counsel's submission is that in that case is that it's dangerous to read the rules of attribution as set out by Lord Hoffman across from criminal law to civil law, and indeed from case to case. So yes, that obviously there are different restrictions which are put in place when we're here talking about the questions of policy involved in fraudulent activities, and as a matter of policy, the court applies them in different ways in different contexts. But within the context of a purely civil case, where all one is talking about is whether a transaction can be affected by members of a company and therefore attributed as an act to that company, the fraud exception in my submission is simply, or at least arguably, an extension of the ultra vires point, because it's obviously not something which the company ought to have done. Now, the consequences that might have in criminal law are a different question with respect to Milady, and as I say, it might simply be that all Lord Hoffman was summarising in that section is that really you can't, obviously, as a matter of logic, do something which you're not allowed to do.
I mean, these are really important questions, because there must be many offshore companies which come within the offshore financial services industry, which are set up in this way, i.e. to obscure the beneficial owner, the ultimate beneficial owner. And so the offshore company registration agents and onshore director has to rely on the unanimous consent of the corporator.
Well, that's right, Milady. And the question then becomes on in those circumstances where the member has set that company up in that way, absent some proof or at least allegation of fraud as part of the operations of the company, can criticism be made of the member's conduct? The member has set up the system, as the judge found, where he seeks to emasculate the usual director's powers and duties in order that he can use the company as his own vehicle. Now, there are certain risks associated with that for the director, obviously, and we'll come on and discuss the solvency question. And sometimes those risks can be militated against by indemnities or other contractual arrangements which the directors can put in place, and sometimes they cannot. But the basic premise of what the member is or is not allowed to do is limited only by these broader public policy questions which relate to fraud, an illegality and acts ultra vires the company. Otherwise, sorry, my lady.
No, sorry, I just interrupted again. I apologise.
No, well, I was only going to conclude that if it were otherwise, the courts would be effectively interfering with what would be internal relations of the company that had no sounding outside of the company. It becomes a totally different picture if, in fact, the conduct of the members, the acts of the members, with or without the directors, and all the directors, are in fact part of a fraud being perpetrated on creditors or third parties.
Thank you.
But there's no reason, in my submission, for the court to use the tools of fraud to limit the powers of the members in their conduct in relation to solvent companies.
But it might be said, and I'm just throwing out ideas, I'm not expressing a view, that in that situation, it was as a matter of public policy, the professional director and registration agents, if engaged and relevant, ought to be making the odd inquiry instead of accepting everything as sort of blank checks. I think somebody used the expression yesterday.
Perhaps I can address that along with the other putting on inquiry
Absolutely.
points, because I think it's a parallel question, if I understand my lady correctly, to the one relating to solvency and whether there ought to be flags waving, which the directors should take account of. And I'll make submissions if I may on that point in relation to Ciban and other principles that arise there.
Yes.
So can I touch on the other limitation, or one of the other limitations on the principle, which is the question of solvency, which will feed into my discussion about Ciban and red flags. The fact of the matter is, not to lose sight of the reality of this case, that Spectacular is not insolvent. The events we're here concerned with took place 19 years ago. The company is and was at all times a holding company for property. It wasn't a trading company. That you can see from Justice Bannister's decision in the papers that you were taken to yesterday. And for what it's worth, he refers to that, the learned judge, in paragraphs 22 and 67 of his judgment. Now, there was no real risk in the actual circumstances of this relationship that this would be an insolvent company, because it didn't trade. And as I've shown you this morning, it didn't even have a bank account. There was evidence at trial, and I don't suggest, well, I'm not putting forward evidence that this is something that the respondents knew prior to the trial, but the evidence was that this was a building which had tenants, but that it didn't, in fact, receive the rent from any of those tenants, whether they were arm's length tenants or connected to Mr. Byington himself. That being the case, as we've just discussed, this is one of those companies where Mr. Byington effectively treated the company as his own. And putting aside for a moment the questions my Lady Arden raises on policy and red flags, that in my submission will be an end of the case. Because if there was no risk of solvency, and as a matter of fact, there's no bad faith or fraudulent activity being perpetrated against third parties, then the multinational gas principle operates completely as a complete answer to this. And so the statement together, as my lady puts it, of the principle of ostensible agency and the principles in Duomatic and multinational gas would then be a complete answer to the claimant's case. And for that reason, as I think now Mr. Hubble accepts, the question of the specific director's duties under the statutes or at common law would fall away. I'll turn then to the red flags point, but I do want to do this, if I may, in the context of and taking the board to the decision in Sequana. I understood that the case was going to be heard before the Supreme Court in March, but I was informed this morning by the registry, no doubt because of its timing, that hearing was adjourned and hasn't been relisted. It is then, I think the website even suggests that my Lady Arden is going to be on the panel in due course, but unless I'm corrected, as I understand it, the case hasn't been heard in the Supreme Court, and so the Court of Appeal decision stands.
That is the position, Mr. Thompson.
I'm grateful for that clarification.
Mr. Thompson, I don't want to interrupt you. If you're moving on to the red flag submission now, would this be the sensible point to take a break, or do you want us to look at Sequana first and then take the break?
If I can be given another 10 minutes, I can probably take the board through those passages in Sequana that I'm interested in showing, and I can stop before making detailed submissions on it.
That is absolutely fine. Thank you.
I'm grateful. So Sequana is a case which considered two separate points, and only one of them is relevant for us, and that is the one described in the report as the first appeal, which is in the head note, the first holding, dismissing the first appeal. The duty under section 1723 of the Companies Act, that should be 2006, was triggered when the directors knew or should have known that the company was or was likely to become insolvent, with likely meaning probable. So this is a case concerning the payment of a dividend and whether that payment should have been made if the directors knew or ought to have known that the company was or was likely to become insolvent. The other point in the appeal is dealt with in the first part of Lord Justice David Richards' judgment. Lord Justice David Richards is the only judge in the Court of Appeal who gave a reasoned judgment. Lord Justice Henderson and Lord Justice Longmore agreed with him without their own analysis. But if I can just show you what Lord Justice David Richards said about this particular question, it starts at page 2205 of the report, paragraph 105. And here, Lord Justice David Richards is explaining that the appeal, BTI's appeal, is against the dismissal of its claim that payment of the May dividend was authorised by the directors of AWA in breach of their duties as director. Such duties were owed to AWA, and as mentioned above, AWA assigned this claim to BTI, which was substituted as claimant. And at 107, there is an encapsulation of the principal issue here. The principal element in BTI's case is that directors owe a duty to consider the interests of creditors in any case where a proposal involves a real as opposed to remote risk of creditors. That encapsulates the issue. I want to take you to three other cases which are considered by Lord Justice David Richards in the course of his judgment, and then to his conclusion. Firstly, could you look at page 2212 of the report, where Lord Justice David Richards deals with the seminal authority of West Mercia Safety Wear and Dodd, starting at paragraph 137. And after reciting the facts of that case at 138, the learned judge says at 139, the liquidator brought proceedings against Mr. Dodd, the director, to recover £4,000 in interest, and the trial judge found that the plain and obvious intention of making the transfer was to reduce the overdraft, and hence Mr. Dodd's personal liability as guarantor. This was therefore a fraudulent preference and a breach of duty on the part of Mr. Dodd. However, the trial judge dismissed the claim, partly in reliance on comments in this court's decision in multinational gas. As to that, Lord Justice Dillon, in Dodd's itself, with whom the other members of the court agreed, said at 252, the multinational case was, however, a wholly different case from the present. In the present case, the West Mercia Company was at the relevant time insolvent to the knowledge of the directors. They had been expressly told not to deal with the company's bank account, and Mr. Dodd had, in fraud of the creditors of the company, made the transfer to the Dodd company's account for his own sole benefit in relieving his own personal liability under his guarantee. In the multinational case, at the time the transaction which was in question, the company concerned was amply solvent, and what the directors had done at the bidding of the shareholders had merely been to make a business decision in good faith and act on that decision. It subsequently turned out to be a bad decision, but the position had to be decided on the facts at the earlier stage, where the company was amply solvent, the parties were acting in good faith. So Lord Justice Dillon, as I mentioned before, the judge who gave reasoned judgment in both Multinational Gas and Dodds, distinguishing those two cases from each other. Then go forward, please, to page 2219. And I want to show you here how Lord Justice David Richards deals with a case that counsel relied on called Brady and Brady, starting at paragraph 159. And Lord Justice David Richards said, I should mention a case in this court on which Mr. Thompson, that's not me, by the way, placed some reliance, Brady and Brady. And that was a case about the acquisition of shares and unlawful financial assistance for the acquisition. And Lord Justice North said, picking it up at F, the interests of a company or artificial person cannot be distinguished from the interests of the persons who are interested in it. Who are those persons? Where a company is both going insolvent, first and foremost come the shareholders, present and no doubt future as well. How material are the interests of creditors in such a case? Admittedly, existing creditors are interested in the assets of the company as the only source of the satisfaction of their debts. But in a case where the assets are enormous and the debts minimal, it's reasonable to suppose that the interests of the creditors ought not to count for very much. Conversely, where the company is insolvent or even doubtfully solvent, the interests of the company are in reality the interests of the existing creditors alone. That passage is, subject to the addition of even doubtfully solvent, consistent in scope and rationale with Lord Justice Dillon and West Mercia. However, Lord Justice North went on to say, and what is accepted here is that Brady remained solvent after the dispositions had taken place, and also that they were made in good faith, that is to say, without any positive intention to defraud creditors. But there is no evidence which shows that the interests of creditors were ever considered. The directors never asked themselves whether half the assets would in all eventualities be sufficient to discharge all the existing debts. The proportion of the assets being removed was so large as to make it essential for that question to be asked. Since it was not asked, it cannot, in my view, be said for the purposes of an exception to the provisions in section 151 that the directors considered that the dispositions were in the interest of the two companies. The most which can be said is that they considered they were in the interest of the shareholders. Now, pausing there, that is in substance Mr. Hubbell's submission. He says, well, if you didn't ask the question, it can't have been something which was in good faith, and it can't have been in the interests of the companies. And but that was a point dismissed by Lord Justice David Richards, as it had been by Lord Oliver when that case went on appeal. Mr. Thompson commented that this was a demanding test and went further than he was prepared to submit. Mr. Thompson was right to take this approach. The decision of the Court of Appeal was reversed by the House of Lords on almost every ground. The second passage from the judgment of Lord Justice North was specifically disapproved by Lord Oliver, with whom all the other members of the House agreed. So that second passage there, paragraph 160 of this report, is disavowed by counsel, had been disapproved by Lord Oliver, and was not supported by Lord Justice David Richards. So that is simply not the law. Then just to take the last case in this, referred to by Lord Justice David Richards in his look at the case law, at page 2223, there's a reference to Bilter and Nazir. And I'm conscious that my Lord Hodge was one of the judges in that case, and I won't labour the point. All that I want to take you to here is the fact that Lord Justice David Richards referred to Sir Andrew Morritt as Chancellor's decision in that case, and Lord Justice Patton's judgment about when the duty is triggered, when the company is or is likely to become insolvent. That's in page 178. And then over the page at paragraph 179, there's a reference to the joint judgment of my Lord Hodge and Lord Toulson, where they said it is well established that the fiduciary duties of a director of a company which is insolvent or bordering on insolvency differ from the duties of a company which is able to meet its liabilities. Now, if you then go forward to the conclusion, which is at page 2228 and following of the report, you can see that Lord Justice David Richards, starting at paragraph 192, refers to his discussion of the authorities and explains that's for two reasons. First, it was Mr. Thompson's submission that the authorities established that the trigger for the common law duty to have regard to the interests of the creditors was when a company faced a real as opposed to remote risk of insolvency. Secondly, as section 172, that's of the Companies Act, applies to the common law duty, it is necessary to identify the trigger as it appears from the authorities. So the question which now Lord Justice David Richards is engaged with is when does the trigger arise? And you can see his conclusion about that after a few more pages of analysis, and in particular analysis of how the Companies Act came into being, at page 2232, paragraph 213. The authorities and the submissions in this case suggest that there are at least four possible answers to the question of when the creditor's interest duty is triggered. First, it may be when the company is actually insolvent, either on a cash flow or balance sheet basis. The decision in West Mercia authoritatively establishes that at least at this point the duty is engaged. Second, it may arise when the company is on the verge of insolvency or nearing or approaching insolvency. Phrases such as these have been used in a number of cases. Third, it may arise when the company is or is likely to become insolvent. This, I think, is what judges mean when they refer to the company as being of dubious solvency. And fourth, it might be the trigger advanced by BTI, where there is a real as opposed to remote risk of insolvency. And over the page at 2233, you can see at paragraph 214 that the learned judge rejects that fourth test that was being advanced by the appellant in the case. A real as opposed to remote risk of insolvency is not part of the present law. And he rejects in the following paragraph 213 the first possible answer. The duty may be triggered when a company's circumstances fall short of actual or established insolvency. And at paragraph 213, the learned judge says that there are problems with the second category, being on the verge of insolvency, because it suggests a temporal test. And then at 222, the judge effectively concludes that the test which had been stated by Sir Andrew Morritt and Lord Justice Patton in Bilter was the one which was correct, which was effectively the third of the four tests that he had decided. The point, just before the break, my lords, the point I wanted to make on this case is that all the analysis is when the duty is triggered. And that's what that case is about and will be when it comes before the Supreme Court, at least on this point of the appeal. The case is about when the duty actually arises. And as you can see from the extract where Lord Justice Richards deals with Lord Justice Norse's case, this is not a case where there's a sort of general duty to think about whether you need to take account of the creditors. There might be such a different duty depending on the director's obligations under contract or otherwise, but this duty to consider the interests of the creditors, a duty owed to the company, is only triggered when the company is insolvent or is likely to become so. And all the debate is about that. So the first point I want to make, and the last one I'll make before the break, is that this is not a general duty that falls upon directors at all times. It's a duty that is triggered when the company is or is likely to become insolvent on the law as it currently stands. If the Supreme Court changes that, it is likely, in my respectful submission, to change it to one of the second or fourth of Lord Justice David Richards' tests. But still, in my submission, the law is and is likely for the foreseeable future to be, this is a duty that has to be triggered before it arises. I'll develop that submission, if I may, after the short adjournment, and I'm conscious I've overrun the usual time.
That matters not, Mr. Thompson. You'll have approximately 30 minutes left to you on your return.
I'm grateful. My estimate was hopeless then.
In case you have time, the case I was referring to is Roll Steel Products and British Steel Corporation, a judgment of Lord Justice Slade on the duomatic principle.
I'll review that case again, my lady. I'm grateful.
Thank you.
We adjourn for 5 minutes. Thank you. Mr. Thompson, you may continue your submissions. Thank you.
I'm grateful. So that brings me back to the question of whether any red flags were waving in this case, and ought to have put the respondents, in particular TCCL, as director of the company on inquiry to question the otherwise ostensible authority of Mr. Costa. And the question, just to frame it, is it a red flag, or were there red flags in the circumstances where the director of the company was being asked to execute a power of attorney to permit the sale of 5 properties owned by the company? Now, there is no duty on the facts which has been triggered that means the directors have to have concern for or take account of the interests of the creditors, because as a matter of fact, whether it was known at the time or not, this was not a company which was insolvent or was likely to become insolvent. It isn't even something that might have been inferred from the power of attorney. The absence of provision in the power of attorney for what is to happen to the proceeds of a sale is neutral. It can't be said to be an indicia of a fraud or an action which is going to leave the company insolvent, that it doesn't say anything about it. Equally, it doesn't say anything suspicious about what's going to happen to the proceeds of sale, or anything suspicious about the sale at all. There can have been then no reason on receiving that instruction from Mr. Costa to suspect that the power of attorney would be used to sell the properties at an undervalue, or to divert the proceeds of sale. Otherwise, then they ought to have been paid. And there's no reason at all to suspect a fraud. You can, a suspicious person, maybe even a very cautious person, might have thought to dig around and to ask questions about it. They might have been concerned to understand more of the background, because it is evidently the case that on the receipt of those instructions from Mr. Costa, the full picture is not available to the directors. But in my submission, that cannot be equated to there being a red flag. What you need in the circumstances of this case is some grounds to suspect something. That's why it's a red flag and not a requirement to dig underground. You're looking for something waving above the ground, not looking for something which you have to dig up in the ground. The circumstances are telling. It is a BVI company that holds property that doesn't trade. These types of companies are something which the directors, being BVI directors, would have taken into account, knowing full well that these sorts of companies, in the usual course of things, are not used for fraud. They are used often to hold property and are often used for reasons, perfectly legitimate reasons of confidentiality and secrecy. There are many reasons why individuals in various countries might want to keep their financial affairs secret from their enemies or even the state. But the circumstances do not, of this case, do not indicate to a reasonable person that there's going to be a fraud perpetrated. And it is of some significance, in my respectful submission, that a very experienced commercial court judge in the British Virgin Islands and 3 local Court of Appeal judges from the region thought themselves that there was no cause for concern. And if you read Mr. Justice Bannister's section in his judgment which deals with the red flags, which is, I think, paragraph 40, I've lost the page, I've lost a screen, I'm afraid, and a page. But where Justice Bannister deals with this, he uses language such as no cause for concern, and this doesn't excite suspicion. It's paragraph 52 of his judgment at page 2131 of the record. And you can see from the way he deals with the half a dozen alleged red flags is to say that he doesn't think these things should have excited suspicion or caused any concern. With my respectful submission, that's the right language to use when what we're here talking about is whether the instructions should put you on inquiry. There has to be something there to give you cause for concern, not something which might, if you are of a suspicious mind, be hiding something nefarious. There needs to be something on the face of it. And it is also telling, this is a forensic point which I advance tentatively, that even 19 years after the event, neither Mr. Byington nor any of his lawyers or 4 experienced judges of the region thought that there was anything suspicious at all in the lack of detail contained in the instructions from Mr. Costa about what was going to happen to the proceeds of sale. The red flags which were alleged in the pleadings at trial and before the Court of Appeal did not include the one which is posited by my lady, Lady Arden. They were, as the judge recites in paragraphs 52 and 53, to do with the fax numbers, the phone numbers, the email addresses, and where the documents were to be sent, and what was said to be the unusually wide terms.
But there are some fairly general allegations in there about failure to make inquiries and so on in the statement of claim. We could go into it. There's some pretty general wording, but I agree with you, it wasn't specifically put. And I just wanted to have views about what it was.
Yes. No, Malady, let me be clear. I'm not suggesting, as a pleading point, that the point's not open to be raised. What I'm suggesting is that it would be a struggle from learned friend to suggest that this was a red flag waving in the wind when nobody had even thought of it for 19 years. That doesn't seem very red or very big as a flag if it is so hard to discern that nobody has managed to do that in 19 years. And this is, as I say, a question of whether somebody has put on inquiry. And if it is something which isn't obvious, then it's less likely to be something which could be said to be putting a person on inquiry. And you can compare that, if only for forensic purposes, with the red flags usually identified in the case law. And we looked yesterday at Satria. Compare that case to this. Satria, the putative purchaser of the assets in that case, had done due diligence on the vendor and knew firsthand that the authority on the part of the company to sell its assets vested in the board. Nevertheless, it claimed that a sole director signing the HOA in that case had ostensible authority. That was the starting point of the of Lord Kitchen's analysis of why Satria was put on inquiry. It was a one-off sale of the only asset of the company into which which was affected by a sole director, Mr. Jonas, with him receiving on the face of it direct financial benefit from the transaction and offering an indemnity. Red flags in that case about that very transaction. Compare that with our case. It doesn't have any of those hallmarks at all. This is the 5th of 5 powers of attorney that are being asked for by the very same man who always asked. It contains exactly the same level of detail, if not more, than the previous powers of attorney. It has more detail than the 2nd and 3rd power of attorney, for example. It's not a one-off. It does involve a property, and as it happens, all the property of the trading company. There's no other company in the structure, unlike in the Satria case, and there's no personal benefit being derived by Mr. Costa from the transaction. So just comparing the two cases, and I'm conscious this is definitive, you can the alleged red flags are nowhere near as noticeable as they would be in and indeed many other cases where people are taking agents as having a without inquiring about their basis. That leaves me only to deal with, I think, the singularis line of cases, and we've touched upon this a little, and so my submissions on here, I suspect, have been trailed already. Those cases, singularis, Bilter, Stone and Rolls, the later two being referred to in singularis in the passages you were taken to yesterday, are all about the attribution of knowledge, not acts, by the way, knowledge, to a company in circumstances made by the company against third parties. And the defence raised in those cases has been, well, the wrongdoing of the individual actor ought to be attributed to the company, or more precisely, the knowledge of the fraudulent individual ought to be attributed to the company in order to defeat the claim. And what Bilter and Nazir makes exceptionally clear, and singularis supports, is that depends on the particular circumstances of the claim that is being brought, because for policy reasons it can't be right that a company, when in liquidation and therefore effectively being managed for the benefit of its creditors, is bringing a claim against some third party who is accused of acting in breach of their duties, that it can't be defeated in that claim by reason of the fact that the wrongdoing was somebody who at the time had control of the company and whose knowledge might in other circumstances be attributed to it. So those cases are nothing to the point, because these third party scenarios, and I just want to make good that point by reference to two paragraphs or two sections in singularis, and then subject to questions from your lordships and ladyships, that would be my submission. Singularis 452 of the record, I don't think my learned friend took you to the two sections I'm taking you to. Apologies to him and you if he did. But at 3452, Baroness Hale is dealing with the starting point of this case. Paragraph 10, if I can read, says, starting point must be the judge's findings, none of which is under appeal. She held that there was no good reason to make the payments to Saad Air, and that it was a breach of fiduciary duty for Mr. Alsanea to direct Singularis to make them. She also held that the agreement made between Singularis and the hospital to pay the expenses of the hospital was a sham, appropriation of the company's money by Mr. Alsanea in breach of his fiduciary duty. As sole shareholder, he was not entitled to ratify the misappropriation of company funds, because he must have known that the company was on the verge of insolvency, and his duty as director was to act in the best interest of the company's creditor. And pausing there, in that passage, and indeed in the passage from Lord Justice Norse in his case, there is an equation between bad faith and acting otherwise than in the best interest of the company, and fraud. It's a misappropriation of funds, and that is almost always going to be the case, that if there's a fraud on the company, it is likely to be at the expense of the creditors. And so the question of solvency and fraud are often two sides of the same coin. But paragraph 11, Baroness Hill refers to the learned child judge's decision. She went on to hold that Daiwa was in breach of the Quince care duty on the facts of the case. Any reasonable banker would have realised that there were many obvious, even glaring signs that Mr. Alsanea was perpetrating a fraud on the company. Go forward then, if you will, to paragraph 34, which is at page 3459. And this is, I think, slightly after the section Malone Friend took you to, dealing with stone and rolls. But Baroness Hale says at 34, but in any event, in my view, the judge was correct also to say that there's no principle of law that in any proceedings where the company is suing a third party for breach of a duty owed to it by that third party, the fraudulent conduct of a director is to be attributed to the company if it is a one-man company. In her view, what emerged from Bilter was that the answer to any question whether to attribute the knowledge of the fraudulent director to the company is always to be found in consideration of the context and the purpose for which the attribution is relevant. I agree, and if that's the guiding principle, then stone and rolls can finally be laid to rest. So my lords and ladies, that's the crux of it, that when one is considering attribution in the context of a fraud claim involving third parties, then the context and the purpose of the exercise of attribution are the critical questions. But that is not this case. Hypothetically, that might have been a sister case to this, but it simply isn't this case. And so my Lady Arden's questions probing the limits of the principle are not ones, in my respectful submission, that we need to engage with on this case, because this isn't a case where there was insolvency or any duty to consider the interests of the creditors, and it isn't a case where there was a fraud. And at its very highest, all that can be said is that there was a fraud or a lack of bona fides on the part of Mr. Costa in his relations with Mr. Byington. But that being the case, the decision in this case and the law which we're engaging with in this case is nothing to the point, because nothing in this case would prevent Mr. Byington from prosecuting a claim against Mr. Costa for fraud. And there is some suggestion he might even have done so in Brazil. And so those principles are nothing to the point. The only question is whether the instructions from Mr. Costa to the respondents were ones which could be taken by the respondents as having Mr. Byington's authority, given the course of conduct and the relations, and then parenthetically whether they were put on inquiry. And in my submission, there were no sufficient circumstances in this case to put the respondents on inquiry, and that being the case, the instructions of Mr. Costa as a matter of law should be seen as the instructions of Mr. Byington, and he had authority to bind the company, thereby alleviating any duty on the directors, because his act was an act of the company which he and the company cannot now complain of. Yes, my lady.
I just wanted to ask you a question. It was going through my mind that company registration agents and indeed company lawyers have a tiresome practice of insisting on resolutions in a formality, and it all printed out at a meeting held, it was resolved. And it could well be that that practice is there because of the limitations on unanimous consent. Namely, it can't be fraudulent and all the rest. The difficulty might be said to, in this case, is that the whole setup of Spectacular was a fraud to defraud the creditors of GEL, and that the very foundation of the authority on which TCL had to rely was Byington's assent to Costa giving instructions with which TCCL had to comply, for which TCCL had never required a resolution of the shareholders, which would of course be the holders of the bearer shares. But they were simply acting on the basis of the EUBO's assent. And might it not be said that that's not really what professional directors and registration agents should be doing? They should insist on a proper resolution. Otherwise, they do lay themselves open to the question, well, was it all a fraudulent setup?
Well, Malady, I think there are two answers to that question. The first is that even if they had done that on this case, the precise fraud that your ladyship is in here concerned with would not have been obviated. So take the case where, in fact, or the parallel hypothetical case in a different universe, where in fact Mr. Byington had wanted these 5 properties to be sold. If in that scenario the directors, TCCL, had invited Mr. Stolman, or whoever held the shares at that point, to execute a formal shareholders' resolution in that regard, he no doubt would have done so, because that was Mr. Byington's will. The fraud that my lady here posits would still have been extant, and whatever complaint the creditors or victims of that fraud had would be just as live as they would be now. So the basis for the directors seeking that formality is it may well be to protect them from that sort of claim, but it wouldn't have given them any comfort in this particular, on the facts of this particular case. The other,
the test, is it, under Duomatic? That's not the test. You have to rely on the unanimous assent of the UBO, and the courts have effectively said, if you wish to do that, then it has to be shown that it's not fraudulent.
In relation to the specific transaction?
Well, that's the question. Does it have to be? Because you have to rely on that unanimous assent for the first leg of your argument.
well, yes, but in relation to, I'm not sure which is the first and second now, in relation to the ostensible authority point, if there's nothing suspicious about the instructions per se, then the authority of the member is then, as a matter of law, given to the agent who provides the instructions. The question then becomes whether that can be an act of the company. Now, if it is a company which is insolvent, or it is an action which is a fraud, then obviously the Duomatic multinational gas principle is undermined vis-a-vis that particular resolution, that particular decision. It may well be a risk. To take solvency, which is, if you like, the less heated question, it may well be a risk that the director is taking, but as that extract from the Sequana case shows, where Lord Justice David Richards is dealing with Lord Justice Norse's case of Brady and Brady, that is the fact that there's a risk doesn't mean that there is a duty on the directors to consider that possibility in every scenario. So actually, you're thrown back to the case about whether the particular transaction is in fact a fraud or in relation to an insolvent company. And that simply isn't the position here, which was going to be my second answer to your ladyship's question. The facts of this case simply don't admit of that possibility. And in a case which is brought, as this one is in tort, one simply can't go further than that and consider whether there were some sort of breaches of fiduciary or other directors' duties which were incurred at the time when they should have been taking account of these things. The reality of it is that this company was solvent, and this particular transaction was not a fraud on a creditor or third party or anyone else. And the highest it can be said is that it was a fraud, or at least against the wishes of Mr. Byington. The substratum of the company and the operations of the company are not relevant to that question. Precisely because, as I submitted, the different possible ways in which the director might have protected itself would all be ineffective in the face of a claim, a larger claim of the entire company's purpose being fraud. I don't know if that answers my lady's question.
I'm very grateful for your answer.
I should also apologise, my lady. Because I had a minor technological problem, I haven't been able to look at the Roll Steel case in the 5-minute adjournment. I'll try and have a look at it well, I'm not sure we'll have time now, but I don't know if there's anything I can further add on the case that your ladyship had in mind.
It's just a neat encapsulation of the duomatic principle.
I'm grateful. Those are all my submissions in answer. I hope I've addressed all the questions from the panel, and I think my time is up in any event. So unless I can assist further, those are my submissions.
Mr. Thompson, thank you very much. Mr. Hubble.
My Lord, thank you. My Lord, as with Mr. Thompson, I had the position overnight in relation to the company and rents, which was a question that my Lord Hodge had raised yesterday. And in fact, the two sets of further and better particulars that were provided by Spectacular are in the record, and so do form part of the bundle before the council. And for my Lord's note, it's pages 879 to 881 and 890 to 896. And what that shows in those further and better particulars is that from the period from 1997 through to December 2001, the claimant company did not derive full commercial rent from the property. The property was about 50 to 60% occupied by various different entities, some of which were part of Byington family group of companies, and some of them were not. And those are detailed at page 891 to 893, my Lord. And then in June 1999, plans started with a view to developing the property so as to rent it commercially to third parties, but those plans were not developed because of the problems that arose with the quiet title action following the sale to Mr. Law in December of 2001. But my Lord, my submission in relation to that aspect is that the key point is that it was indeed the purpose of this company to hold the property. That was its key role and its key task. And that is not an unusual situation at all in a jurisdiction of the sort that one has in the BVI, where it's very common to have a single purpose company that exists for one particular function. And I submit that what is plainly important in those circumstances is that the director may not have the sort of onerous suite of duties that a director who's got day-to-day management of a company has, but that the director nevertheless is obliged in those circumstances to undertake due diligence so that they know who is authorised and for what purpose to provide instructions on behalf of the member. And that simply was never done here. And there were no steps ever taken to ascertain what authority, if any, Mr. Costa had and for what purpose. And it remains the case in my submission that the director still has the obligation to know the affairs of the company so that they can discharge their duties responsibly. And that is likely to engage, as I say, first, basic due diligence so that they understand who they should be receiving instructions from, but also an understanding of the affairs of the company and the terms of any proposed transaction, so that the director can establish if there is applicable BVI legislation that requires to be addressed and dealt with. And one example of that in these circumstances is Section 80 of the IBC, where in order to know whether that act was engaged or not, the director needs to know, first of all, what are the assets of the company? Secondly, what proportion do the assets that are going to be potentially sold reflect of that amount, and what is the ordinary course of business of the company. So in order to know whether that act is engaged, the director has to know certain basic things about the company and its operation. And in my in relation to section 80, of course, we submit that there was a tortious duty actually owed to ensure compliance with section 80, and that tortious duty was breached. I'm going to come on to that in a moment, if I may.
Mr. Hubbell, yes, I would like you to come back to that, because the assertion by Mr. Thompson is that that isn't available, and I would like to know if there is any local jurisprudence on the remedies available under Section 80.
Right, my lord. Well, I can certainly address the first of those. I'm not certain I'll have the complete answer to the second, but I'll come on and deal with that in a moment. But if I may, just by way of introduction, just to also to frame my submissions, that in terms of what I would say the irreducible duties of the director in this situation, the director also needs to know what the basic affairs and assets of the company, so that the director can consider whether or not the result of the transaction is that the company is going to be rendered insolvent. Now, my learned friend's taken you this morning to the authority of Sequana in support of the proposition that that duty doesn't arise. But what Sequana is addressing, the trigger point at which a director comes under an obligation to protect or consider the interests of the creditors. That it's the creditor's interest duty, and the trigger for it is what is being addressed by Lord Justice David Richards in that case. My point is slightly different. It is that when one is looking at the framework within which the director has to operate, the director has to know sufficient about the affairs of the company and a proposed transaction to know whether applicable legislation is potentially engaged, and to know whether there is a risk of insolvency. And if those basic steps have been taken, just as if basic steps have been taken to ascertain whether Mr. Costa actually had the authority of Mr. Byington, then Mr. Costa's scheme would have been uncovered. Spectacular's case is not that the directors owed a duty expressly to protect the interests of the creditors on these particular facts. The case is that the director owed a duty to the company to know the affairs and assets of the company, and part of the framework for that is applicable legislation and the potential duties to protect creditors. With that introduction, if I can turn first of all, my lord, to the suggestion that the case in relation to section 80 is not open to Spectacular, and for that purpose, can I ask the court to look at the contents of the third amended statement of claim, and in particular, if we might start, please, at page 2200. And if we could go, please, towards the foot of page 2200 to paragraph 3.6a under the heading Duties Owed by Tortola Corporation. And it is there said, as the sole jury director of Spectacular, Tortola Corporation owed Spectacular the following fiduciary and or tortious duties. And then at Roman numeral 3, the duty to exercise the care, diligence and skill that a reasonably prudent person would exercise in comparable circumstances. And that is echoing the language of section 54.1 of the Act. Specifically a duty, and then if one goes down the page to 2201 E, to ensure that any power of attorney executed, including the power of attorney executed by TCCL in favour of Mr. Delolo, included and was subject to all appropriate legislation, including Section 80 of the International Business Communities Act. And then separately at Roman numeral 4, a duty to comply with all applicable provisions of prevailing companies legislation, and in particular the IBC. So a duty to ensure compliance with section 8 is, in my submission, squarely pleaded. And if one goes on, please, to 2211, one sees paragraph 6 underneath the heading in bold, summary of breaches of duty, and it is there said, claimant will rely on the facts and matter set out above. Further, and by way of summary, each of Citco and TCCL acted negligently and/or in breach of fiduciary duty in the following respects: in and about the sale of the property, improperly issued POA, and the subsequent documentation necessitated by the proposed sale. And if one then went on to page 2212, and to Roman numeral 8, there is the particular failing to heed or comply with the requirements of Section 80 of the 1984 Act in relation to the proposed disposal of the property. By way of example, failing to submit a proposed resolution in respect to the sale of the property to and/or obtain the approval of Mr. Byington by members' resolution. And at Roman numeral 8A, failing to ensure that managing relevant obligations under the relevant company's legislation, including Section 80, were included and complied with by the power of attorney executed by TCCL. So in my submission, both a tortious duty and a breach of that duty is squarely pleaded. And then, but by way, or I hope at least partial answer to my Lord Hodges' question, the way that Spectacular puts its case is that the director had an obligation to ensure compliance with applicable BVI legislation, as indeed was admitted, and that included Section 80, and they failed to do so. And had they done so, then Mr. Costa's scheme, the unauthorised scheme, would have been uncovered and would have come to the attention of Mr. Stallman and or Mr. Byington. Because what Section 80 required in the circumstances was the obtaining of a member's resolution. So it is, the question in my submission is not what is the remedy for a particular breach by a company who fails to comply with Section 80 of IBC. The question is, did the director act in breach of their duty of care to ensure compliance with Section 80? And if they did, what is the consequence of that?
Well, I don't really understand that point with respect, because that can establish a breach of duty, but the question then arises: what was the remedy envisaged by the statute for that breach?
Well, my lord, the particular point that I submit is that the tortious duty is on the director to ensure compliance with that section of the Act, and it's not about the particular remedy, for instance, an availability to set aside the transaction that may arise so far as the company is concerned. It's about whether the company would have been protected in the event that it had been complied with, and had Section 80 been complied with, the transaction wouldn't have happened, because there would have been a request made for a member's resolution.
I can see that, but are there any cases in the BVI which says that if you breach Section 80, if a director breaches Section 80, he or she is liable in damages for a tort, rather than, as Mr. Thompson asserts, that the remedies are to unscramble the transaction by nullifying it, or if the transaction isn't complete, an injunction. That's the point I was wishing to be insisted on.
My Lord, the answer is I'm not aware that there is any authority in the jurisdiction that does so find. And the conclusion of the judge at first instance was that the remedy was a remedy of the sort that my Lord has identified. But the framework of my submission, as I say, is I submit that the directors had an obligation to ensure compliance with prevailing BVI legislation and to ensure that, for instance, the transaction didn't result in the company becoming insolvent. And had they undertaken the basic steps to comply with those duties, then Mr. Costa's scheme would have been uncovered.
I understand that is your submission, but the short answer, it is a matter of assertion that the statute envisages that a claim for damages in tort is the result of the breach of that provision.
My Lord, yes, save that at the risk of repeating myself, my submission is that even though this was a company, the primary purpose of which was simply to hold the property, the directors retained certain key responsibilities. One, to only act on authorised instructions, I say, on behalf of the member, and two, to know the affairs of the company properly or sufficiently so that they can discharge their responsibilities. And in order to discharge their responsibilities, they have to know whether legislation is going to be engaged.
I mean, I don't think you need to repeat your position on the question of duty. Your position is clear, but the answer, as far as the board is concerned, that neither your assertion nor Mr. Thompson's assertion as to what the available remedies are to be is backed up by authority. Lord Leggatt, I think, raised his hand first.
Am I right to understand, Mr. Hubble, that your case is not based on a claim for breach of duty of Section 80 itself? Your claim is that it was a breach of the director's duty of care to fail to investigate and discover the relevance of Section 80.
My Lord, yes, and to ensure compliance, but it's of a duty of care owed by the director to the company.
And then there's an incidental consequence of that. It would have uncovered the lack of authority, although it wasn't direct. There may be a causation or scope of duty question, but that may be for the second stage as to whether, if it just so happened that as a result of that separate responsibility, it had turned out that Mr. Costa didn't have authority and that had stopped the transaction, whether that gives a claim or not.
Well, my Lord, a similar point it occurred to me as being something that could be said against me in relation to my Lady Arden's questions in relation to a need to consider whether the result would be that the company would become insolvent.
Indeed, all those sort of questions.
But my answer to that, my Lord, is partly that might be a question for a later stage, but it is also that what we are here addressing, and my submission is that notwithstanding the particular circumstances and the findings of the trial judge, that there are certain key or core duties owed by a director that remain, and the framework for those it do include complying with applicable legislation, do include considering whether the result of the transaction may be that the company becomes insolvent. And here, the director simply did nothing and didn't arm themselves with any of the information that was necessary. And had they done that, then Mr. Costa's scheme would have been uncovered.
Lady Arden, I think, had a question as well.
Yes, I've been mostly preempted, but I think your answer is it's all covered by director's duties. And I was just going to make the observation, could you also say that that would explain why Section 80 itself doesn't include a remedy for in the form of an action for breach of statutory duty? Need a setting aside?
My lady, yes. Because I think of a subtle but important distinction between a claim for breach of a statutory duty and claim for breach of a common law duty of care owed by a director to a company. part of which is to ensure compliance with a statutory obligation. If I may, could I turn away from section 80 and to deal with another pleading point that was raised by my learned friend, which was that the suggestion, and I think this becomes relevant in the context of the application of the geomatic principle, the suggestion that this was not pleaded and presented as a fraud case, which was one of my learned friend's submissions yesterday. And the short answer to that is that this was not pleaded as a fraud case in the traditional sense against these respondents or against these defendants. So it's not surprising that it was not expressly pleaded as such, because Mr. Costa is not the defendant. The case against the defendants was that they facilitated and enabled the sale of the property by their negligence and indeed by their complete disinterest in relation to material facts surrounding the transaction. What was pleaded at paragraphs 4.1 and 4.2 at page 2202 to 3 was that the sale of the property was unauthorised and it took place without Mr. Byington's knowledge and consent, and that it was at a price far short of that which is pleaded as being at least real 3.6 million. And similarly, it is pleaded at paragraph 4.6 at page 2204 that Mr. Costa's authority was terminated in November 2000, and at paragraph 4.8 at 2205 that Mr. Costa had no authority from the company or Mr. Byington to provide instructions on behalf of the company or Mr. Byington, and that the correspondence in November 2001 was undertaken without the knowledge of the company or Mr. Byington. And then finally, it's pleaded at paragraph 6.4 at 2213 that if Citco BVI and or TCCL had complied with their duties, then the unauthorised scheme of Mr. Costa would have been detected and prevented, and the apparent sale of the property would not have occurred. So in my submission, it certainly it is pleaded that the transaction that was undertaken following the request from Mr. Costa it is not an honest and bona fide transaction so far as the company was concerned. And that is the relevant plea in my submission so far as the limits or exceptions to the geomatic principle is concerned. And the position even on my learned friend's submissions, as I understand it, is that it is accepted that Mr. Costa was not authorised by anyone in respect of the fifth power of attorney for the sale. Mr. Costa was chasing Mr. Byington for money he believed was due to him in the period from May to July 2001. And then, as we see from the form of completion statement that my lord was taken to this morning at 2056, what happened was that Mr. Costa took the sum of real 316,759 of the sale proceeds, i.e. of the company's money, for himself, a fact which was recorded by the judge at paragraph 16 at page 2123. So in my submission, that there can be no dispute but that Mr. Costa was unauthorised and he took money from the proceeds of sale for himself. And indeed, the judge referred to Mr. Byington, in his view, taking the risk of that betrayal at paragraph 50 of his judgment at 2131. And so in my submission, it's really beyond argument that the transaction was not honest and bona fide insofar as the company was concerned. It was plainly not in the company's interest. Indeed, certain of the money that was generated by the sale, the part payment that was made in respect to the sale, was appropriated by Mr. Costa. If I may turn to pick up in my remaining time, a couple of points, if I may, in relation to agency, and then the question of the duomatic principle. In my submission, agency is the relevant first stage in the analysis, because unless Mr. Costa had the authority of Mr. Byington in some shape or form to provide instructions to Citco, BVI and TCCL, then they simply had no business dealing with those requests. So what one, my lord.
Surely that isn't right. The question is whether they were negligent in treating him as having authority.
Well, my lord, I accept, of course, that it is a claim brought in negligence against TCCL and against Citco BVI, but on the face of it, if a director acts on an instruction from someone who in fact is a stranger because they don't have authority, then in my submission it must follow that they've acted negligently.
Well, it may often do so, but in this case, the judge found that it didn't, because the whole system had been set up, to their knowledge, by Mr. Byington in a way which required them to act on his instructions without checking with Mr. Byington, because he wanted to remain in the shadows. So that's a finding of fact against him.
Well, my lord, that in my submission, the correct way of analysing that is that there were no steps taken by the director, or indeed by the registered agent who acted on the request, to ascertain what, if any, authority Mr. Costa actually had to make requests on behalf of Mr. Byington, and that process was simply never undertaken. And so in those circumstances,
you invite us to find that that they were negligent, even though two courts below have found that they weren't.
Well, my lord, I do, because in my submission, the question of agency is relevant, and the question of agency was simply not addressed by the judge, because the agency is the stepping stone to whether the defendants were entitled to rely or to react to the request that they received from Mr. Costa. My lady Black.
If they had made inquiries in relation to attorney number 4, they would in fact have found that he was content for Mr. Costa to pass over his instructions. So the question then becomes, did that change?
My lady, yes, save that in my submission, the change, or a change that takes place between the 4th power of attorney and the 5th power of attorney, is that Mr. Costa resigns, and as a matter of fact, although the judge didn't analyse it in these terms because he didn't analyse it in terms of agency, as a matter of fact, Mr. Costa ceased to have the actual authority of Mr. Byington to pass on requests and instructions.
We're looking at whether they're negligent, and that is taking us into the red flag area, isn't it?
My lady, perhaps, in which case the answer it this way, if I may, which is whoever did make those inquiries, had they made those inquiries, they would have, on the judge's findings, they would have, it would have become clear that Mr. Costa was authorised at that stage to pass on those requests. But they didn't. And what actually evolved was a practice whereby Mr. Costa simply made a request by fax or email, and it was responded to. And as a matter of fact, there never was any due diligence done or any checks done to establish that Mr. Costa did have that authority. Now, I quite appreciate that in relation to those first 4 powers of attorney, Mr. Costa did. but the defendants never actually went through that process. So far as on the face of their files, they never ascertained what authority Mr. Costa did or didn't have. Now, time came when he no longer had that authority on behalf of Mr. Byington. And in my submission, that's why one has to consider the question of agency and whether they were entitled to rely on the request that was received. Then I quite agree that there is a second stage in the analysis, which is whether there was something about the fifth power of attorney and the circumstances in which it and the documents in November were sought that should have put them on inquiry.
Thank you.
If I, Lord, you have my submissions, I hope, in relation to the question of ostensible authority. I do say that there is, in effect, a two-stage process so far as the defence of the respondents is concerned. And the first stage of the process is, was Mr. Costa authorised to provide instructions on behalf of Mr. Byington? And the second stage is, what is the effect of that, which engages the question of geomatic and the multinational gas. In relation to the first of those points on ostensible authority, I simply highlight that each case, of course, turns on its own facts, but it is not correct, as my learned friend seeks to do, to equate the judge's finding that Mr. Byington arranged matters, which is the wording in paragraph 50 of the judge's judgment of first instance, with Lord Sumption's statement in Kelly and Fraser as to how the company there arranged its affairs. Because in Kelly and Fraser, Mr. Masters was the vice president of the company responsible for employee benefits, for the employee benefits division, and corresponded in that capacity. So in my submission, that's the material distinction, is that in that case, there plainly is a holding out by the company of Mr. Masters as having authority to pass on communications on behalf of the trustees. In contrast, in this case, there never was any equivalent process. There were simply faxes and emails in the name of Mr. Costa without any express association with Mr. Byington as they came in. So that's why in my submission, there isn't a representation that emerges from Mr. Byington. If I may turn to the question of red flags, I highlight, if I may, first and foremost, that this was the fifth power of attorney, a document that was going to be used to dispose of the properties on any terms. And there we engaged the fact that it was found by the judge and relied upon by the judge that the defendants didn't know that this was going to be used for the purpose of disposing all of the properties held by the company. But as I submitted, that is to make a virtue of the past defaults of the directors, because they should have known what the assets of the company were. And here one simply receives a request out of the blue. I think it was 16 months following the previous communication. The last communication was in April of 2000. A request comes in on a personal email address, power of attorney, in wide terms, that is going to enable the sale of the property on any terms. And that plainly, in my submission, called for inquiry. And it called for inquiry partly as to whether Mr. Costa had authority to provide that instruction, which is the question being put for inquiry as set out in the East Asia Company, but also the director is put on inquiry. As I've said, they've got to understand enough about the affairs of the company and enough about the terms of the transaction to discharge their duties appropriately, and that was simply never done. My learned friends suggested that the November 2001 documents really don't add anything to the analysis, because the question of whether or not the respondents were on inquiry falls to be determined in August 2001. I simply submit in relation to that there's no logic to that suggestion. One has to consider the circumstances of the requests in April 2001 and the further requests in November 2001. And those requests in November 2001 are important for two reasons. The first is that those emails make clear to Citco BVI that this was the sale of all of the company's assets. That was 2341 to 2342, but this was something that was simply not reacted to. And the second is that even if one only analyses the position of Citco BVI as a registered agent, Citco BVI is marshalling all of the documentation to enable the sale of the property, including the certificate of good standing and the certificate of incumbency, which it itself issues. And then finally, if I simply say as following in relation to the geomatic principle, I say first, what we're actually dealing with here is it was a request made by Mr. Costa for the production of a power of attorney. And in order for the geomatic principle to apply, that request has to become treated as unanimous assent of the shareholder to the transaction. And in my submission, that is an unwarranted extension in circumstances where, at best, Mr. Costa only had ostensible authority. But in any event, the transaction was one that was not for the benefit of the company. It was not bona fide and honest for the benefit of the company. We know that it was not authorised, and we know that the effect of it was that Mr. Costa took part of the sale proceeds for himself. And in those circumstances, it would be an extension of the geomatic principle. And the answer, for instance, doesn't lie in Sequana, as I've submitted, because this isn't about when the creditor's interest duty is triggered, but about the framework within which one has to consider the duties of the director. Yes, Lord Burrows.
Could I just take you to section 60, just to understand your precise submission? Section 60, I beg your pardon, section 80
Yes.
of the IBA, section 80, sorry. On the face of it, looks like it imposes a strict duty on the director in those circumstances. But as I understand your answer to my Lord Legate, you're not making that submission that there's a breach of a strict duty. You are only putting forward a submission that there's a breach of, by the director, of a duty of care to have complied with that. Is that right?
My Lord, yes. What I say is that there was a duty of care which extended to complying with applicable legislation, but the strictness of section 80 is relevant because its terms, in order to discharge the duty owed to the company, you have to ensure compliance with section 80, and that would have involved, under subparagraph A, the proposed sale must be approved by the directors, and under paragraph B, that the proposal for the members has then to be authorised by the members themselves.
But why are you adding in reasonable care, given that on the face of it is a strict obligation?
Well, my lord is, in one sense, of course you're correct, and that's a strict obligation. But what I'm putting forward is that there is a claim to damages for breach of tortious duty, and the claim to damage for breach of that tortious duty is the duty owed by the director to the company.
Yes, I understand that, but I mean, there's plenty of tort claims for breach of strict statutory duties giving rise to claims in damages.
Yes, my lord. Well,
Factory legislation would be the obvious example.
I'm certainly not disavowing that, but I have. But the case as presented at the Court of Appeal, and the cases I've presented is really based on the consequences of that tortious breach of failing to ensure compliance with Section 80.
Yes. On that basis, Mr. Hubble, my question would be irrelevant as to a remedy for breach of a statutory duty. You're pleading an anterior breach of duty.
My lord, yes. But I certainly rely on the strictness of the obligation under Section 80, because I say that's what the director needed to do to ensure compliance with it, which in turn would have uncovered the unauthorised scheme.
Thank you.
Katie, as I understand it, the lower court took it that the duty was owed by the directors to Mr. Byington and not to Spectacular. They also said, well, it was within the usual or regular course of business. What do you say about those?
Well, it's the obligation on the director is to comply with their duty that's owed to the company, and that's why I say that the tortious duty owed to the company is to ensure compliance with the legislation. So it's not about a duty. It's mixing up company law principles, if I may say so, to suggest that the director owed a duty in that way to the member. The director owes the duty to the company, and that duty extends to ensuring compliance with BVI legislation. In relation to Mr. Justice Bannister's finding that it was within the usual or regular course of business, what was identified right from the outset from the sale of Shelf Company Facts on the 27th of October 1997 was that the purpose of the company was to hold property. That was the purpose of the company, and in my submission, it's simply wrong to suggest that a disposal of all the assets of the company, which then removes the company's raison d'etre, can be said to be in the usual or regular course of the business. This wasn't a property trading or development company. It was found to be a property holding company.
Thank you.
I mean, we're now, Lady Arden, but we are now exceeding the time of this case, so I'd ask we keep questions limited at this stage.
Very briefly, following on from Lord Burroughs' question, if the authority of TCCL was execution only, then this Section 80 problem doesn't arise. But secondly, I'm asking really for your observations. Under Section 80, subsections C and D, it's quite clear that the stipulation for a meeting is intended to be something that could be altered in the circumstances of the company. Would it, in your view, include unanimous consent of the UBO?
Well, what I would say in answer to that is that it's building a considerable number of links on what was a request from Mr. Costa for the issue of a power of attorney, to say that that falls to be treated as a unanimous consent of Mr. Byington for the sale of the property, and it effectively as some form of ratification or unanimous consent for the purposes of Section 80. We're building layer upon layer in my submission to get from a request through the geomatic principle into ratification, and it's an unwarranted extension.
Thank you. Well, the board is very grateful to both counsel for clear submissions, and also to those who have assisted counsel in the preparation of this appeal. The board will take time to consider what advice they should humbly give Her Majesty. Thank you. We now adjourn.